case to come before the court is State versus Rome, and each side will have 15 minutes to present their arguments, and the appellant may reserve up to 5.
Thank you. Good morning, Your Honors. May it please the court, my name is Gino Polito. My bar number is 0037912, and I'm here on behalf of the appellant, Brian Gomez. I'd like to reserve 5 minutes of my time, if I may.
That's fine.
Your Honor, this case comes to this court on the appellant's position that there is insufficient evidence to sustain the judgment that was rendered by the judge in the court below, as well as the judgment was also against the manifest weight of the evidence in this case. As the court is aware, this deals with an OVI charge. In order for the state to prevail, it must prove all the evidence with regard to its charge. In this case, there was insufficient evidence with regard to whether or not Mr. Romans, at the time that there was a minor offender bender, was intoxicated. It is clear from the record that the officer that responded sometime after the accident did not observe any bad driving and did not have any typical testing that would be done to determine whether the driver was impaired at the time of this accident. Not only was he not there at the time of the accident and not observe any bad driving, but even after he met up with Mr. Romans some 2.5 hours later, the officer did not ask for any and did not receive any fetal sobriety test. He didn't do any breath, urine, blood tests, other things that would typically establish the level of alcohol impairment with regard to this case. So, not having any of that information, the only other way that he would be able to sustain his burden, or the state would sustain its burden, is based on a trustworthy eyewitness, which in this case they're relying on a witness by the name of Rebecca Broomer, that was a passenger in a vehicle that was part of this fender bender on the night of the accident, or the morning of the accident. Ms. Broomer has shown to be anything but a trustworthy and reliable witness. Ms. Broomer, first of all, didn't give a written statement until 3 days after the event occurred. The written statement was given to her, or given by her after reflection and after discussions with her mother. In fact, although she testified to a number of things that would indicate impairment, she did not contact the police, citing that there was this driver who was impaired. She asserts that they first saw Mr. Romans slumped over and passed out as a result of being intoxicated in his car. In fact, when the police officers met up with Mr. Romans, he was far from an individual who had been passed out 2.5 hours earlier. He was alert. He invited the police officer to his house. They had a conversation. And he had imbibed during the period of time that he left the scene after making arrangements to fix the vehicle that had been hit. He had imbibed in some additional alcohol. Nevertheless, he was not passed out. He was alert, and he did have a significant conversation with the patrolman in that case. Further, the information that was given, even days later, by Ms. Broomer was fraught with inconsistencies and exaggerations, as admitted by the police officer. For example, she indicated that Mr. Romans hit her car, a car that she was a passenger in and also owned by her mother, at a rate of 40 miles per hour. In fact, the physical evidence reflects that there wasn't that type of an impact. There was no debris on the road. There wasn't any significant damage to the car, both for Mr. Romans' car as well as her car. There just wasn't the objective evidence that would ascribe to the fact that this vehicle had been in that series of an accident. She further indicated that Mr. Romans went through yards, dug up dirt, left trenches because of the soft terrain in private yards. In fact, there was no such evidence that in fact occurred. Photographs were taken by the officers of Mr. Romans' car, which showed no damage to his vehicle. Photographs were taken also of Ms. Broomer's car, which showed some modest damage, which would be consistent with a fender bender of 5 to 10 miles per hour. Ms. Broomer's testimony was inconsistent in many other ways. Not only did she fail to call the police if she thought that Mr. Romas was intoxicated, but the only time and reason she called the police was after the automobile accident, after speaking with her mother, who asked her to call 911, and it was merely for insurance purposes to make sure that the vehicle would in fact be repaired. Mr. Romas was a friend of the driver of this vehicle, and after the accident, they stopped, exchanged information, and in fact, made arrangements to fix the vehicle at a shop that each of them worked at that repaired autos. The driver of the vehicle, who was interviewed by the police officers shortly after the accident, indicated to the police officers that while he saw Mr. Romas at a bar, he did not see him consuming any alcoholic beverages. Ms. Broomer had to admit that while Mr. Romas had ordered shots at the bar, he was buying those shots for friends. Consequently, there isn't any evidence that was presented at trial that would indicate that Mr. Romas was impaired either physically or mentally to an extent that he would be chargeable under the OVI statutes.
Was there some testimony that he stumbled when he either got out of the car or got into the car? Did the witness testify to that in addition to having seen him slumped over the wheel?
Yeah, the testimony, Your Honor, is accurate in the recollection. The testimony came from the same witness, Rebecca Broomer, who has exaggerated throughout the record with regard to the events. That just didn't happen.
So I understand the position that you take with regard to whether or not the conviction was against the manifest weight, but we obviously review all of the evidence for sufficiency in a light most favorable to the state. So if the witness said the words, I'm having difficulty following your position on sufficiency, why the evidence is not sufficient.
Well, we think that the courts have to take a look at the reliability of her testimony when you take everything in total. She also said that he hit her car at 40 miles per hour, which just didn't happen. She also made other overt statements that just were out and out exaggeration if not lies. And consequently, the credibility of what she actually saw comes into light. Mr. Romas testified that that wasn't the case. He was not slumped over, and he wasn't stumbling. He was alert. In fact, after the accident, they had dialogue. One of the things that Ms. Broomer misrepresents and misstates is that after the accident, they couldn't stay there because it was dark and she felt for her safety. When in fact, right at the corner where this occurred, there's a huge parking lot that is well lit, and the officer testified to that, where they could have pulled over and exchanged information. They were going to a mutual friends, and he was fine to drive, and there wasn't any issues with regard to that. So the totality of the story that she said, it just makes her an incredible witness that I don't think the court should have relied on the information. And certainly, you're right, it does go to the
I'm sorry, I thought you were done, I apologize. What about her mother?
The mother alleged to have had a conversation by telephone with Mr. Romas the day after, where Mr. Romas allegedly told her that he had been drinking. That conversation, the phone call occurred, as Mr. Romas testified. The conversation that he told her that he had been drinking did not. The conversation that he told her that he would repair the car did.
That he what?
He would repair the car.
Yes.
Did. And he explained that there was a fender bender, that in fact they exchanged information, and it was his intention to correct the vehicle.
Why would they have any reason to lie? Shouldn't their interest only be that their car is repaired?
Well, their interest went beyond that, Your Honor. In fact, during the stage 4 restitution, they wanted thousands of dollars in personal injury. And so I think the basis for the lie is to extract money from Mr. Romas.
I was going to say that, but I mean, they could, I guess that may help them in regard to a civil suit.
Yeah, certainly if he's going 40 miles an hour, it's a better suit for them than if it's a fender bender. Certainly if they can exaggerate his level of intoxication, jury that would give the civil suit would have a different impression of what transpired.
Can you remind me again what time it was that the trooper showed up at his house?
5:30 in the morning, Judge. The accident occurred around 3:09, at least that's when the police were called.
And when the police showed up at his house at 5:30 in the morning, he's got a whiskey and a beer in his hand?
That's correct. Or some intoxicating beverages. I don't recall if it was whiskey or vodka, but he was drinking it. If there's no further question, I'll reserve the balance.
That's
of my
fine,
time.
you have about 5 minutes left. That's fine. Thank you.
May it please the court, Mr. Polito. My name is John Quillen. I'm here on behalf of the state of Ohio. I'm with the Medina Law Department. In the words of Pedro Sanchez in the movie Napoleon Dynamite, I don't have a lot to say. When I was a defense lawyer, I would often be on the wrong side of a verdict or a decision, and my client would say, well, we'll appeal. And I would say, okay, what are our grounds? Well, I'm innocent. And I'd say, I understand that was our position. We tried our hardest. But what grounds? Well, they lied. They would say, they lied. And I would have to say to my client, what did the judge do wrong? What did the judge do wrong? Well, the judge didn't do anything wrong. I said, well, that's what appeals are about. What did the judge do wrong? What did the trial court do wrong as an error that the Court of Appeals would need to step in and evaluate? So when we focus on what it is that Judge Chase in this particular case, well, what did Judge Chase do wrong? Now, I didn't try this case. Attorney Barbera of our office did. This was before I started with the City of Medina, but I read the transcript, and it looked like a pretty good trial to my observation. That is, the issues were raised and they were argued. The state of Ohio had their witnesses. They were fully cross-examined. The defense put on its witness, also subject to cross-examination. And Judge Chase, as a bench trial then sits, of course, as both finder of fact and finder of law, decider of law. And it's up to Judge Chase, as the finder of fact, taking the place of the jury, to not only hear what is said, which is what we as the readers of the transcript would have seen what was said, but also to evaluate other cues of candor, credibility. I listed in the brief those things we tell the jury in a jury instruction. This is what you're allowed to use, not only what you hear, but the feeling you get, are the eyes shifty, candor, lack of it, frankness and lack of it, etc. And Judge Chase, as sitting as the finder of fact, also had benefit of those visual cues that we don't have. The judge is free to believe some part or none of any witness testimony pursuant to the law, and the judge clearly found enough evidence to convict the defendant of the OVI. There is evidence, if believed, supports that. It's certainly sufficient, and I would suggest it would be incumbent upon all of us to defer to the trial court's rulings, being that he was in the room, he's the guy in the room, and then he has benefit of the vibe and the feel and the non-visual cues as well as the visual, as well as what was said that we see on the transcript. So,
and having, I think, you're arguing to 3 judges who have had trial court experience, so we're following you in terms of what happens in the actual courtroom and the importance of giving deference to the person who was there. But, as appellate judges, we also have to contend with situations where there are inconsistencies in the evidence, and when you have the state's witness saying, the trooper saying, well, this witness just, not fabricated, but certainly exaggerated testimony, and that happens more than once, it does create some concern.
that's your trial court brain talking, I would suggest, and the appellate court brain perhaps would be, I would suggest I might have done it differently. You might say I might have done that differently, and certainly you can envision yourself. All of you can envision yourself in that same spot. What would I have done if I was the trial court. And
No,
then-
I'm talking
no?
about the 13th juror kind of situation where we look at the manifest weight. That's where I am.
Right, right, but I think that there was a, if I could cite a case, it was in the brief, State v. Smith here in the 9th District. I'm sorry, it's State v. Cavan, citing State v. Smith. The court will not overturn a trial court's verdict on manifest weight only because the trier of fact chose to believe certain witnesses' testimony over the testimony of others. And what you're suggesting, I know, is that you're seeing the defects and flaws in the testimony of one of the witnesses, and that should be considered, and that should be evaluated. I would suggest that it was, and that's what Judge Chase, as that finder of fact, did. And there is evidence there, and if believed, that evidence is sufficient. And if not, not. And I'm only suggesting respectfully that the deference to the things that we don't know, maybe the judge knows from being in the room. I don't know. I wasn't there either. But I appreciate your thought on that, and it's a matter of, I would suggest, it's a matter of, again, trusting the person in the room, unless the person in the room, I mean, by that I mean the trial court, manifests such behaviors, analysis, or total disregard, or maybe they found found evidence where there was none, rather than side evidence where it was conflicting. That would be the 13th juror function, in my view, is to stop an injustice, stop a judge that just did not do, in this particular matter, their proper job, and so that justice was not done. Yes,
Did
ma'am.
Mr. Gass testify as well?
I don't recall, I'm sorry, I don't recall if he did or not.
Just curious.
So that's really all I would have to say, other than responding to any questions the court may have.
I don't believe so. Thank you.
Thank you.
Thank you.
Just briefly, Mr. Guest did not testify, but the trooper relayed a written statement that he received from Mr. Guest, who again had indicated he had not observed drinking on the part of Mr. Gomez during the time that they were in the same rooms and confines, and nor did he articulate to the trooper any bad driving. He didn't articulate any slumping over the wheel. He didn't articulate any stumbling, which obviously if he was passed out over the wheel 2 hours prior to stumbling 2 hours prior, he would have also been in worse condition 2.5 hours later when a trooper talked to him at the home, which wasn't the case. The typical case with regard to trustworthy witnesses deals with the probable cause to stop, and whether the trooper can or the officer can rely on information received by a trustworthy witness. Then the trooper takes over after making a legitimate stop based on the information that he receives from such a witness and confirms what transpires by his own independent testing and observations, which weren't here. We believe the sufficiency of evidence deals specifically with that the trooper had absolutely no information, either by observing or by a credible witness, to make this arrest. There is no evidence with regard to what blood alcohol level Mr. Gomez had at the time of this offender visit, nor is there any other testing that would show that Mr. Gomez was either unconscious, physically unable, or mentally unable to operate his vehicle on the freeway. For those reasons, we believe that this matter should be reversed. Thank you, Your Honor.
Thank you. The court will take the matter under advisement and issue a written opinion that will be sent to both sides, as well as release it on our websites. Thank you very much. And thank you for accommodating the court being here today.